judicial review. And what the Constitution in Article 3 delineates is that there's a Supreme Court of the United States that has the power to decide cases and controversies that arise under the Constitution of the United States. So anytime there's a disagreement between the branches of government or a disagreement between the people and the government about how the Constitution applies, the judiciary has the power to decide that controversy. And that's the primary Article 3 power. And now there's a debate about to what extent the decisions they make impact future cases and controversies. And what it is you've probably heard the term, the doctrine of stare decisis. Anytime there's a new Supreme Court justice up for nomination, everyone always talks to him about the doctrine of stare decisis. And what that means is the thing's already been decided. So if they decide something in one case, should they follow or not follow that case in the future? And the general rule is that the Supreme Court should follow its decisions, but all the lower courts, the Ninth Circuit, U.S. District Courts, and even state courts when dealing with U.S. constitutional law have to follow what the Supreme Court has said, their latest pronouncement about each issue. So what we're doing is we're bringing a case and we're asking the courts to recognize that we have the fundamental right to assemble, the fundamental right to freely exercise our religion, and to be free from a state establishment of religion. And those are the three primary rights that we're addressing. There's other ancillary rights. There's the general liberty right under the United States Constitution that's enshrined in the 5th and 14th Amendment, and that says that no one shall be deprived of liberty without due process of law. In that liberty right has been read the freedom to associate, the freedom to move, the freedom to make your own decisions about your health and about your body. And that's where a lot of rights that people say are judicially created rights come from, but really they're defined in the concept, the general concept of liberty. So we're also addressing that issue. Now the way this works is the Constitution created a Supreme Court, but then gave Congress the power to create such inferior courts as they thought were necessary. So what we currently have is we have United States District Courts. There's 4 different district courts in the state of California. We are situated in the Southern District. Every state has a different number of district courts in it depending on the size of the state. So you can find out what district you're in your state. There's generally geographic. We're in the Southern District. There's a Northern, Central, and an Eastern District in California. Other states, wherever you're watching from, you'll have a district court system that's set up slightly different, but there might be a Northern and a South, or just one district court. And each of those district courts answers to Congress-created circuit courts of appeal. Here in California, we're in the 9th Circuit Court of Appeals. There's a 10th Circuit Court of Appeals, an 11th Circuit Court of Appeals, 1st through 8th, and then there's a D.C. Circuit Court of Appeals and a Federal Circuit Court of Appeals. These appellate courts are required to hear any kind of appeal. So if we do not like the decision that a judge makes, in our case, we can appeal it to the 9th Circuit. If either party doesn't like the decision that the 9th Circuit makes, they can ask the Supreme Court to hear the case. It's called a writ of certiorari. That's something that's optional. The Supreme Court does not have to hear any case. They have the right to hear any case, but they don't have to hear any case. And generally what happens is more than 7,000 parties apply every year to be the ones that the Supreme Court hears, and the Supreme Court generally hears less than 150 cases per year. So getting in front of the Supreme Court is difficult, but they give preference to cases where there's a split in districts. So this is all by way of background information. I kind of want to set the framework for you to understand the judicial system that we're in. So the way a case starts, the beginning of a case, is someone files what's called a complaint. And that complaint says that the defendant who is named has in some way harmed or violated our rights. And in this case, what we did is we filed a complaint in the Southern District Court of the United States here in California, and that's saying that this is a federal issue that can't be answered by state courts because it arises under the United States Constitution, even though we're also bringing California Constitution claims, but the United States courts can hear both of those. Again, this is all by way of background information. I want you to understand how it works so that you can understand why the ultimate goal is important. So our objective is to get this case in front of the Ninth Circuit Court of Appeals and in front of the Supreme Court of the United States, so that they can address issues that have not been addressed before, because we've never seen local ordinances like these ordinances that so infringe on fundamental rights. Now, what we're saying to the court, first and foremost, is that these cases, these ordinances, the local county orders, are targeting the right to assemble, because what they're doing is they're saying you're not allowed to assemble. They're doing what's called making assembly criminal. Now, before I get too much into that, I want to back up and talk to you about why this is important. So lower courts are bound to follow decisions of the Supreme Court. And right now, when looking at past decisions of the Supreme Court, lower courts have no decision to look to in order to decide what they should do. And that's why you see a different outcome in Kentucky than you see in California and in Texas and in other states. Every state court system, even though they're all U.S. courts, federal courts, all the federal courts across the various districts and in different circuits are responding to this differently. And what we want is we want the Supreme Court to make a clear ruling saying that ordinances like these are unconstitutional, so that courts have something to look at in the future. Because when we applied to the court for what's called a temporary restraining order, to temporarily restrain these orders so that they wouldn't apply to us while they decided whether or not they were ultimately constitutional, the court only had one case that they could look at, and that was a case called Jacobson versus Massachusetts from 1905 that didn't implicate any of the fundamental rights that are there listed under the First Amendment to the United States Constitution. And that's an important distinction when you're looking at this, because there's First Amendment rights, and Congress and by nature of the 14th Amendment, states and local officials cannot make any law that affects those rights in certain ways. They can't prohibit the free exercise of religion. They can't affect an establishment of religion. They cannot abridge the right to assemble or to speak, or the rights of the press or of the people to petition the government. Those are rights that are fundamental First Amendment rights. There's other fundamental rights in the Constitution, but those are given a place of preeminence because they're the first rights in the Constitution and the first rights laid out in the Bill of Rights, and they're considered to be the highest form of fundamental right that's protected by the Constitution. And again, you have to back up and recognize that the purpose of the Constitution is to limit government. And when you're talking about a representative government, the purpose of the Constitution is to limit the power of the majority of citizens to infringe upon the rights that are recognized in the Constitution that belong to the minority of citizens. And we're dealing with something that's unique in the history of the United States, because for the first time, the majority of the citizens in the United States seem to have lost a value for religion and for the church. And that's something that's unique to our day and age that hasn't existed in the United States in the past. 100 years ago, when they were deciding cases about the Establishment Clause, it was the exact opposite. It was whether or not the states had the right to require religious tests for office, or whether or not the states could mandate that specific religious curriculum be taught in school. And those were the things that the state was trying to do. And that's the context in which decisions were made. So the Supreme Court's never had the opportunity to weigh in on a type of restriction like we're seeing today, where it's a complete ban on churches. And I want to address this because I know a lot of people have brought it up and it's in the news. The 1918 Spanish flu, at that time, the only thing that was banned, and it wasn't tested in any court, the only thing that was banned was assembling inside of a building. So all the churches who wanted to still assemble could go outside. So that's a completely different circumstance than what we're seeing now, where we're not allowed to assemble no matter what precautionary measures we take or how we arrange the service, except now we're allowed to assemble only in our vehicles, which limits what we can do, because we can't do baptism, we can't do communion, we can't do laying on of hands, and a lot of other things that are important to us. Now, we're trying to help the court understand that that is a de facto Establishment Clause violation, because the Establishment Clause says you can't affect an establishment of religion, but really what it's been read to mean is you can't affect an establishment of a certain belief system of any kind, and then impose that belief system on the conduct of people within a state. This is a novel concept. I talked about this a little bit last time I spoke with you. This is a novel concept because the First Amendment says Congress can't do that. And when you think back to the founding, Pennsylvania was a Quaker state. Massachusetts was I believe they were a Puritan state, and different states had specific religions that were in charge of that state, and they passed Sabbath laws, and they made it mandatory to pay taxes to the church, and that was what went on then. Now, the Establishment Clause applies also against states, and so they're not allowed to affect an establishment of religion. So again, the goal is to set precedent. And the only precedent that the court looks at now is Jacobson, which deals with just the liberty interest and not those fundamental rights that I'm kind of describing to you. And I want to address each one of those. So what we're asking the court to recognize is that the state and local government are not allowed to come in and mandate that we believe like they believe, and we consider to be essential what they consider to be essential. Because what they're saying is you can only do the things that we think are essential. And we're asking the court to recognize that that's a violation of the Establishment Clause, that they're basically establishing a state set of doctrines based on the mere opinion of a few medical professionals who have been selected by them, who are ultimately relying on statistical models, statistical computer models that haven't borne out in reality. And the state and county is saying that their mere opinion should be substituted for your opinion and our opinion in regards to our day-to-day life. And they're saying that certain things like medical facilities, marijuana shops, gun stores, potentially even strip clubs, entertainment industry, all those sorts of things are essential, and they're necessary parts of our life, and that if we close those down, everything's going to go haywire, but the church is not essential. And that goes to the next fundamental right, because that's an establishment of them telling us how we're supposed to think about essential and non-essential, and doing something that's absolutely forbidden by the Constitution, which is denigrating our point of view, which is that the church not only is essential, but it's a cure for disease, and that taking communion is more effective than taking a pill, and that coming together and gathering in the assembly is the place in the midst of the church is where Christ Jesus placed gifts of healing and miracles. And they're saying that you can't think that way, that that's dangerous, and they're substituting their viewpoint about what's essential. And not only that, they're now burdening our practice of religion. And that's, there's ways you break out the free exercise clause. And one way that you look at it is if they're targeting the free exercise of religion by saying you can't worship, or in this case, you can't assemble, which is a targeted right, and that's a separate right, and I'm going to talk about that in just a second. But what they're doing is they're targeting the free exercise clause by burdening it. They're burdening our free exercise of religion by preventing us from doing things that we consider to be absolutely essential. Now, the free exercise clause has been narrowly interpreted and very limited by past Supreme Court decisions. One in particular, Employment Division v. Smith, where the court upheld a law and struck down a practice where Native Americans would use peyote, a hallucinogenic drug, in their practice. And the court then weighed in and said, well, neutral laws of general applicability can burden the free exercise of religion without triggering what's called strict scrutiny. So when you're talking about constitutional law and judicial review, the Supreme Court's laid out the framework for analyzing various different types of violations. And what we fall into in the free exercise clause, just based on the basis of the neutral laws of general applicability standard, and what the court said on April 10th and what the county is arguing is that we should fall under the rational basis test. But what we're asking the court to recognize is that in a case where the free exercise clause is burdened to the degree that it's burdened now, while implicating the right to assemble and establishment clause concerns, that they should always apply strict scrutiny both now and in the future. And that's the precedent, the primary precedent that we're trying to set, so that in the future, if no matter what the framework of the majority of the United States of America population is, because that's ultimately the people who are behind the policies that we see. It was the elected representatives of the state of California who passed the Health and Safety Act of California that gave the governor of California and state public health officers and local public health officers power to declare an emergency whenever they felt like there was an emergency, and powers to make laws during an emergency. That power was given by our elected representatives. So this is not something that's anti-majoritarian. And what we're dealing with is ways to limit the power of elected representatives and the power of unelected officials who have been delegated power by those representatives, both now and in the future, as their beliefs and their opinions diverge significantly from what's near and dear to our hearts, which is the Word of God and church. And so that precedent can only be established if someone brings a case in front of the Supreme Court implicating the issues that we're talking about now. So the free exercise clause here has been burdened, and Employment Division v. Smith said whenever you have a burdening of free exercise that implicates another right, then you're back into strict scrutiny. Now the assembly clause comes into play in a big way here because what they're doing is they're prohibiting gatherings. And even the case that they're relying on from 1905, Jacobson v. Massachusetts, says that when there's a plain, palpable invasion of a fundamental right, again, fundamental rights are those that are enumerated in the Constitution, like the freedom to assemble, speak, and to publish newspapers, practice your religion, and petition the government. And the court said when there's a plain, palpable invasion of a fundamental right, then its reasoning doesn't apply. Courts in the lower districts here in California, 3 different courts have ruled that that is a case that applies to uphold the current ordinances. And that was in the Southern District of California, I believe it was in the Eastern District of California in Riverside County, and then the Northern District of California in Lodi. That might have been in the Central. I'm not 100% certain on that, but 3 different district court judges have weighed in California, in the state of California, in the Ninth Circuit, have weighed in and said that these types of ordinances are proper under the free exercise clause. Kentucky decided differently. New Mexico, also in the Ninth Circuit, sided with the California courts. So what we're trying to do is we're trying to bring all of these cases, and especially our case, into the Ninth Circuit so that we can set a precedent that never again in the future can these district judges, uphold these types of ordinances. That all we'll have to do is walk down into a courtroom, file a temporary restraining order application, and then it'll be done because the precedent's been set by the Supreme Court, and they won't have to look all the way back to 1905, a case dealing with a smallpox outbreak and whether or not someone should have to take a readily available vaccine that has very limited side effects. And you compare that to what they're doing now. It's not even an applicable case, but it gives courts something that they can lean on that needs to be repudiated by a higher court. There's a number of different ways that you can change policy in California and in the United States. The first way is through political decision making, but that changes. And again, if the majority has a certain viewpoint or a certain opinion, then they're the ones who get to set that policy. The only other way is to create Supreme Court precedent that limits what the majority can do. And that's what we're primarily trying to do in this case. And that's why we brought it. And again, those are the fundamental rights that we're looking at. There's also equal protection concerns, obviously, when the government gets in the business of saying this is essential and that's not essential, someone's livelihood's essential and someone else's isn't. That implicates the equal protection clause. And there's a lot of other things that are implicated here. But the primary fundamental right is the right to assemble. And the precedent for that we have, and we believe is very strong precedent that's going to get us to the point of winning this case at the Ninth Circuit and in front of the Supreme Court, is a case called DeJonge versus Oregon. And that case was in the 1940s or 50s. I can't remember exactly when. The Supreme Court weighed in on a statute that banned any kind of act that was subversive to the interests of the United States. And the state of Massachusetts applied that to any gathering of communists because they were dealing with an emergency then. The emergency they were dealing with was the spread of an idea. What we're dealing with right now is the emergency trying to stop the spread of a virus. So you can see there's some kind of similarity there. And in the context of stopping the spread of an idea, which was considered by the court to be a compelling interest, just like they would consider stopping COVID-19 to be a compelling interest. In that context, the Supreme Court said you cannot make assembly a crime. And that's exactly what they've done in this case. Here in San Diego County, they've prohibited all gatherings of more than one person. They've made assembling a crime. And so we're bringing that in front of the court. And even if the United States District Judge refuses to recognize that precedent, we know that that's something that the Ninth Circuit and the Supreme Court ultimately will uphold, because if you violate and plainly, palpably invade a fundamental right, the correct standard is called strict scrutiny, and you look and you ask, well, number one, is there a compelling government interest? And we admit that there's a compelling government interest in stopping the spread of disease. And then you ask, number two, is the restriction on the right narrowly tailored to be the least restrictive means possible? And we know that this is not the least restrictive means possible, because they're allowing any government-favored business to remain open, subject to less restrictive standards than they're imposing on the church. They're not making you stay in your car when you go to the grocery store or to other places that are open. And I know everyone's getting out and seeing that stores and commerce is packed. They're not even making you sit in separate rows or apart from each other on airplanes flying from New York into California. They're packing people in. And so to say that the disease only spreads at certain gatherings that they disfavor or don't consider to be essential is not even rationally based, and more to our point, not the least restrictive means that's available. There's other less restrictive means that are available. So those are our goals and objectives, and that's why this is important, because if we can get in front of the Supreme Court, then in the future, for the next 100 years, 200 years, as long as the Lord delays His coming, there's going to be strong precedent set that courts can look back on and say, no, even in a time of pandemic, even in a time of crisis, the Constitution of the United States is not suspended. And that's an important point, because we're the only Constitution that I know of in the world that doesn't have what's called a suspension clause. The Indian Constitution, shout out to my friends who are watching from Kashmir, the Indian Constitution has in it a suspension clause. In a time of an emergency, the Prime Minister or the Parliament or other delegated officials can suspend the Constitution and everyone loses all of their rights. That's the norm. England has a suspension clause. Most constitutions around the world have a suspension clause because they haven't been dedicated to what the United States has always been dedicated to, which is that even in times of emergency, the Constitution is not suspended, that people still maintain their rights, and that when those rights are violated, they have a remedy in the court to declare that those rights were violated so that it doesn't happen in the future. Now, this is where things really get interesting, because you look at, there's times where the Supreme Court gets it wrong, and the doctrine of stare decisis seems to limit that and allow them to change their mind in the future. And there's a couple key examples where they've repudiated past cases. One was the Dred Scott decision I believe it was in the 1850s or early 1860s, and that's where the Supreme Court of the United States held that someone based on the color of their skin was not a human being. And that's a case that's now been repudiated. It was repudiated by constitutional amendment with the 13th Amendment and then ultimately the 14th Amendment, and then by future Supreme Court decisions saying that that case was wrongly decided. Another case that was repudiated was called Korematsu, and in that case, the United States took all the Japanese citizens of the United States and put them in internment camps. And since then, the Supreme Court has said, well, we got that one wrong too. And there's been other examples where the Supreme Court says that it's been wrong. We're looking at them doing that again. And so the doctrine of stare decisis gives a little bit of room in cases where the Supreme Court gets it wrong. But when they've upheld the rights of the citizens, have they decided that their past decisions were wrong. They've only decided they were wrong when they've upheld the rights of the government as opposed to citizens. So what we're asking them to do is to uphold the rule of law in the United States, the existence of a constitution, the whole concept of a limited government, that the government isn't the one who can come in and tell you what's important to your life, what you can do, what you should eat, where you should go. That we shouldn't be ruled by what Ronald Reagan called a few intellectual elites, a small intellectual elite somewhere far away in a capital who are going to tell you how you're supposed to run your life. And the whole purpose of the Constitution is to prevent the government from being able to do that, to protect minority viewpoints from imposition by the majority. So I'm going to leave you with that tonight. I want you guys to think about that. Thank you again for joining us. I'm so blessed to be able to talk to you about this, and we're looking forward to seeing this case completely resolved as soon as it can be, and we want you all to know and be in prayer about it so that you can know exactly what we're doing.